Good afternoon, welcome. Thank you all for coming. I'm Nate Kazmarek, the director of the Article 1 Initiative at the Federalist Society. We're very excited to be here in Russell Senate Office Building and to have a great discussion about the 17th Amendment. First, let me say thank you to Senator Ron Johnson and his HISGAC staff for their kindness in sponsoring the room. Also, a few updates before we start about the Article 1 Initiative itself. Recently, we announced our second annual writing contest. This year's theme is Ambition, Counteracting Ambition, Enduring Principle, or Failed Experiment. Cash prizes of $5,000, $2,500, and two honorable mention $1,000 prizes are available. For more information about the writing contest, you can check us out at fedsoc.org/AI contest, fedsoc.org/AI contest. One more quick update. Last week, we were very excited to launch our new website. It's a much better platform for staying up to date on the nationwide conversation we're trying to have regarding restoring Congress's place in the constitutional order. On the website, you'll find information about the more than 100 events we are doing on Capitol Hill and across the country this year. You can also check out our latest videos, blogs, white papers, and of course, the Necessary and Proper podcast. The new website can be found at fedsoc.org/articlei or articleiinitiative.org. Please visit the page and let us know what you think of it. And now for our panel. We are so pleased to have a great moderator and panelists today. Full bios for each of them have been provided to you on our website, and the emails going out for today's event. So I will quickly provide you very abbreviated versions of their history. Our moderator today is Todd Teittleman. He is the Deputy General Counsel for the Office of General Counsel in the U.S. House of Representatives. He has been with OGC since 2011. Prior to that, he served as a legislative attorney for the Congressional Research Service. His BA is from Boston University, and his law degree is from Catholic University of America, Columbus School of Law. We are also happy to have with us Professor Todd Sawicki, who is the Foundation Professor of Law at the Antonin Scalia Law School. He is a senior scholar of the Mercatus Center at George Mason University and a senior fellow at the F.A. Hayek Program for Advanced Study in Philosophy, Politics, and Economics. Since 2006, he has served as co-editor of the Supreme Court Economic Review and is author of more than 70 articles in leading law reviews and peer-reviewed economic journals. He clerked for Judge Jerry E. Smith from the U.S. Court of Appeals for the Fifth Circuit. He received his A.B. from Dartmouth College, his M.A. from Clemson University, and his J.D. from the University of Virginia. And rounding on our panel is Professor Garrett Epps, who is a professor of law at the University of Baltimore School of Law, where he has been teaching constitutional law and creative writing since 2008. Professor Epps is a contributing editor for The Atlantic. Among other books, he is the author of American Epic, Reading the U.S. Constitution, and American Justice 2014, 9 Clashing Visions of the Supreme Court. He received his LLM in Comparative and International Law and his J.D. from Duke University. He earned his M.A. in English Writing from Hollins College and his BA from Harvard College. Gentlemen, thank you all for joining us. Mr. Teittleman, the panel is yours.
Thank you, and welcome everybody. Coming from the institution where there is no doubt about how you get elected to become a member of the House of Representatives, I will say at the outset that I don't have an institutional dog in this particular fight, although I do have a incredible interest in how our colleagues across the chamber are elected and appointed to their various positions. So this should be hopefully a very interesting panel and a robust discussion that I look forward to participating in greatly. And then with that, I will turn it over to Professor Sawicki for his opening remarks.
Well, thanks everybody for coming out today. And basically the case I'm going to make is for why we should repeal the 17th Amendment. And if we're not going to repeal the 17th Amendment, what we can learn about the original Constitution and constitutional architecture so as to understand what the framers were trying to do with the original composition of the Senate, and in terms of constitutional structure and other goals, and the ways in which the repeal of the 17th Amendment undermined those goals in ways that perhaps even the supporters of the amendment didn't foresee. It's a real pleasure to be here with you, and it's a real privilege to share the podium with Garrett Epps, and I kind of want to just sit down and let him tell stories about Virginia politics in the 70s, but maybe we'll do that over a bourbon on some other occasion. I was recently doing a interview for a podcast for a series on the Constitution that NPR is doing, and the interlocutor says to me, he says, "So I understand you're one of the leaders of the movement to repeal the 17th Amendment." And I laughed and I said, "Movement? It's all half dozen of us, most of whom I know from the internet, and trust me, I don't have any desire to meet in person. But what I do know is that most people haven't even ever heard of the 17th Amendment or knew that senators were ever elected a different way from how we do it. And that includes law professors. And so when I've spoken on this topic to law schools and that sort of thing, you can see as I start talking about the 17th Amendment for all the professors who haven't read my paper ahead of time or didn't have the paper, there's like, you can see them count 14, 15. And I say 17th Amendment, direct election of senators. They're like, oh yeah, of course, right? Under the original Constitution, United States senators were elected by state legislatures. That changed in 1913 when the 17th Amendment was passed, which provided that senators shall be directly elected by the people. Historical evidence suggests that in some way or another, it may have been the case that the 16th Amendment that provided for the income tax, empowered the federal government to levy an income tax, in the 17th Amendment were kind of contemporaneous, maybe kind of went together. And one possible story is that they were just both part of the progressive movement. We had the Reconstruction era amendments, and then we had no real constitutional amendments to the until the progressive era, in which case we had the 16th and 17th Amendments, and then we later had prohibition and the like. And obviously, that is a crucial threshold. And in many ways, we think of the New Deal as being the pivotal moment that changed American constitutional history. But in many ways, the New Deal was kind of a mop-up operation, in my view, after the 16th and 17th Amendment so fundamentally changed the powers and the limits on the federal government, unleashing the income tax through the 16th Amendment, obviously, and then, as I will argue, the 17th Amendment fundamentally changing the system of federalism and separation of powers. Now, if you look at the framers, and I'll just be brief on some of these, when you look at the framers, what did they have in mind when they wanted to have senators elected by state legislatures? They had a number of things in mind. The first was they had in mind that the U.S. Senate would function as sort of a House of Lords in the American system, right? Which was indirect election of senators, was designed, in their view, to basically create a situation in which people of great esteem would be elected to the Senate. Generals, lawyers, business people, like sort of paragons of the community, and these would be the people who would find it beneath their dignity to engage in the hard scrabbling of seeking out votes, like all those aggressive guys down there in the House, right? And so they would be exalted figures. Now, to some extent, at least, one might say that that was true, right? Tocqueville, for example, when in Democracy in America, Tocqueville talks about the high quality of the people who compose the United States Senate, compares them very favorably to the upper houses of traditional European parliaments in terms of the learning and the dignity of those guys, right? Now, that does never really serve much of a purpose in the United States in a democratic system. I'll leave it up to you to think about how this might, whether that was actually the case. Watching television and some of the commentary, I think that there are probably a number of Americans who may not have the same view of the United States Senate today in terms of how they've been conducting business and the like. But that's really just a subjective opinion. What's more important, and I think what most people focus on, is the structural importance of the way in which the Senate was originally composed. And basically, we forget about this, but the Senate actually had two functions, not just one. What people always focus on is the role of the Senate in preserving federalism. And this was very important. And this is a crucial idea, which is that the Senate was supposed to be the protection for federalism, period, full stop. Basically, what the idea was that the House would be elected by the people, and they would be, as part of the federal government. The Senate would be elected by the states and would represent the state legislatures in some sense. Even the locution of the time referred to senators as being ambassadors to the federal government, for example. And the idea here is Madison, and this is the key idea to understanding the original constitutional architecture. Madison says that there's basically, the Federalists say there are basically two purposes of the Constitution. The first was to preserve individual liberty. The second was to frustrate faction. Faction, what we would call special interest now. And we'll come back to that in a second, right? But in terms of preserving individual liberty, what Madison says in Federalist 51 is reliance on the people is, of course, the most important way in which we control the government. But experience has also taught us the necessity of auxiliary precautions. And what were the auxiliary precautions? Things like federalism, separation of powers, and the like, in which case the government was supposed to be sort of self-operating in checking each other through the branches and separation of powers, but also through federalism, obviously, right? The idea was that, as Madison says, you had to align the interest of the man with the constitutional rights of the place. Align the interest of the man with the constitutional rights of the place. So if, for example, if you want the Senate to be a body that protects federalism, you have to make sure that senators find it in their own electoral self-interest to protect federalism, right? And that was the essential idea, was that senators, by being essentially agents of the state legislatures, would be a voice for the sovereignty of the states and to protect the states to the federal government. Was how they had it established, and there's some evidence that it worked pretty well in that sense, right? We could go into some of the details. Turns out it worked pretty imperfectly. So, for example, state legislatures would sometimes instruct their senators on how to vote on things, but they lacked the power of recall if a senator did not do it. But by and large, senators would vote, if they were instructed by their state legislature to vote on something, they would vote the way they were told by the state legislature, or they would resign. And that actually happened on a few occasions. Now, this is an area in which the framers, I think, had a key important insight to align the interest of the man with the constitutional rights of the place. The change in the election of the Senate, I think, has fundamentally changed the way senators see their jobs. They see them as basically indistinguishable from members of the House, right? But in practice, I think this turned out to be, I've learned from my former colleague, David Schleicher, this protection turned out to be much weaker or imperfect, we'll say. It was not toothless, but it was imperfect. And basically what Schleicher points to is the rise of national parties, especially during the Jacksonian era, in many ways overran this protection, right? So, and this is obviously something we continue to see today in the relationships between the branches, which is the rise of parties and partisanship over Madison's structural vehicle in terms of the idea that senators would look out for the Senate. In many ways now, senators are members of their parties first and members of the Senate second, as is the case with others. And I'll just refer you to Nate's opening remarks in terms of the Article 1 writing initiative, which in many ways goes to exactly this question, right? But keep in mind, the framers specifically did not intend to set up a democracy. Right? Only one of the four major constituent groups in the federal government were going to be directly elected by the people. That was the House. The Senate was going to be indirectly elected by state legislatures. The president, in theory, was going to be elected by the Electoral College, and judges weren't going to be elected at all. Right? They were going to be nominated by the president, confirmed by the Senate. Only one of the four branches were designed to be democratic, over time, of course, that has changed. Now, one of the things that's interesting about the progressive era, and one thing that I think is often very funny, is people attack me and they'll say, oh, Sawicki just hates democracy. He doesn't trust the people. And usually that debate ends in one sentence, because usually it's somebody on the progressive side. And usually that debate ends in one sentence when I say, oh, so you're in favor of electing judges then? And they say, well, no, of course. We got to have limits on democracy. And I said, right, that was their point, right? Basically, one might say that this is a proper limit or an improper limit, but the framers certainly, what they had in mind were these auxiliary precautions, right? That the people would be there as a backdrop, but these are supposed to work in a particular way. Whether they work that way, I think, is imperfect. Second thing we forget about is the second purpose of having the Senate elected indirectly was bicameralism. I remember there were two goals that the framers had in mind: preserve individual liberty and frustrate the power faction or special interest. Bicameralism was really about that second one, as were the separation of powers. The idea was that having two bodies of the legislature, right, they called the legislature the most dangerous branch, right, because of what they saw in the Articles of Confederation and the state legislatures, is by dividing them and having them based on two different constituencies, the ideas would be that you would slow down the pace of legislation and slow down the power of factions. They were particularly concerned about majoritarian factions, but it applies to minoritarian factions as well. The idea is if the House and the Senate are elected by the same people, you could put together a coalition that passes things through very quickly. What they had in mind was by having the House, the Senate, and the presidency all elected by different constituencies, that would raise the necessary threshold for legislation to be passed. Thereby, the idea would be is it would try to create a greater consensus and a greater, almost supermajoritarian sense before the government, the federal government would act, which would have a sort of a checking effect, which would then also devolve power to the state and to local governments and to private actors acting through markets and civil society. And I think on that sense, the Senate did do a pretty good job. I think what we see during the 19th century is a lot less special interest type activity. Right after the 17th Amendment is enacted is when we start to see, almost immediately, we start to kind of see a tidal wave of what I think could arguably considered to be a special interest activity and the like. But we forget that that was the second purpose of having the Senate elect by a different mechanism, was bicameralism and the limitations on faction. The third thing I'll just mention that's just kind of an interesting thought, and then I'll wrap up, is if you look into some of the other sort of quirky provisions of the Constitution, it's pretty clear that their provisions seem very closely tied, and if you look at the history, very closely tied to this. So think about impeachment, for example, right? The way in which the framers set up impeachment, where the Senate would essentially sit as a jury and require 2/3 vote in order to convict on an impeachment charge, kind of only makes sense if you think of them as being indirectly elected and having sort of attenuated political constraints on them now, right? I mean, now it's kind of just turned into more partisanship, right? So it raises an interesting question, which is once we decide, once it turns out that senators are going to be elected in partisan elections, should we also be thinking about the impact that has on other elements of the Constitution, such as our impeachment process? Does the impeachment process make any sense in a world of partisan direct elections? Think about, this probably shouldn't be too hard to think about given recent history, think about the confirmation process and the unique role of the Senate in the confirmation process, right? And if you look at the framers pretty clearly had in mind that for judges, for example, what they were looking for is just basically making sure that a judge is qualified and wouldn't be a crony of the president, that they were basically looking for integrity, independence, judgment, and that sort of thing. Obviously, the court plays a much more politicized role today, and that's what's caused a lot of the fights that we see over these things. So there's been exogenous changes. But again, sort of the idea is the role of confirmation seemed very closely tied to the idea that senators were going to have this buffer where they would be independently elected for 6-year terms and have some ability to exercise independent judgment. We also know that the data by Vicamar has found that in the pre-17th Amendment era, senators used to rotate through the government more or rotate in and out of government, right? So the idea of career politicians prior to the 17th Amendment, there was more opportunities for senators like Daniel Webster to move in and out of the government over the course of his career, or move from the Senate to become Secretary of State, for example, or serve in the president, in the executive branch, and move back because of the flexibility that legislatures had in terms of doing these sorts of things, which I think was also consistent with the founders' design. And then once you move to popular election, you get basically the rise of career politicians in the Senate, which is another just sort of, I can't say whether it's good or bad. People may have different normative assessments of that, but it clearly changed a lot of things that you might not think of at first. So where does that leave us? As I said, I don't expect the 17th Amendment ever to be repealed, but I think by learning about the 17th Amendment and learning about what they were trying to do with it, and learning about the logic in terms of thinking about the Constitution in terms of the interest of the man being aligned with the constitutional rights of the place and the incentives of that. Thinking about the separation of powers and how that was supposed to be the primary protection for individual liberty and to reduce factionalism rather than sort of direct democracy and that sort of thing. I think we think about maybe there's other tweaks to the Constitution. Maybe, for example, there was... one of the reasons why I think Commerce Clause jurisprudence was very undeveloped in the 19th century was Congress never really tested the limits of its Commerce Clause jurisprudence, right? Which is the Senate basically blocked them, right? The federal government did things the federal government was supposed to do, navies and armies and interstate improvements and things like that. But a lot of the other things were left to the states. And he never really pushed the boundaries, right? Things like unfunded mandates being imposed on the states. That's kind of inconceivable in a world in which there's where senators are elected by state legislatures, that they would vote for unfunded mandates, right? And so one of the things that leads me to think about is once we take out that piece, that protection, the means for the protection of federalism was that the states would elect senators. But I don't see anything in the constitutional debates that of the 17th Amendment to suggest that those ratifying it thought that they were getting rid of the constitutional value of federalism or bicameralism. They just wanted a different means, but I think in the end, they ended up undermining the ends. And so I think whether it's increased judicial review by the courts in a more muscular role or some other sort of thing, thinking about other ways accommodating the democratic impulses that push for this 17th Amendment, think about other ways in which we might go about accomplishing those goals of federalism and separation of powers now that we took out this instrumentality, this pillar that we had in order to preserve it. And with that, I'll turn the podium over to Garrett.
Thanks, Todd, and thanks to the Federalist Society for inviting me here today. I'm always honored to be invited to speak at a Federalist event for two reasons. The first being that the Federalist Society always takes seriously the questions I care about, including the history and meaning of constitutional text and the practical implications of constitutional doctrine. Maybe that's not the most important reason. The important reason is that as a young man growing up in the South in the 1950s, I always imagined that someday I might be good enough at basketball to play for the Harlem Globetrotters. I learned fairly quickly that I didn't have the skill set for that particular occupational slot. But I began to imagine that maybe not being that good, I could play for a team some of you may have heard of called the Washington Generals, whose job was to show up at Globetrotter games, play their hearts out, and lose by 1 or 2 points every time. And I conceive that to be my function here. Today, I'm honored to fulfill it. I love to talk about the 17th Amendment for a variety of reasons. One of which is not terribly germane, is that I'm one of the few people who's actually litigated a 17th Amendment case, which has nothing to do with the part of the amendment we're going to talk about here today, but I'd be glad to talk about. The passage of the 17th Amendment and its adoption in 1913 is a moment of constitutional history that I think it ought to attract acclaim from everybody in this room, regardless of your political beliefs and regardless of the policy outcomes you think it may have contributed to. Because if we believe in constitutionalism, if that is our faith, that the Constitution is a legitimate fundamental bond knitting the nation together that proceeds from a sovereign act of the people and that can be altered only by similar sovereign act following certain agreed upon formalities, then the story of the enactment of the 17th Amendment is deeply inspiring because it is a story of prolonged, serious popular mobilization to address what its framers and advocates believed, I think with some reason, to be problems that had originated with the 1787 text and had grown measurably worse since the Civil War. The original question of equal representation in the Senate, how should senators be selected, there was a lot of struggle and a lot of disagreement among the framers about that. I did notice that for the rest of his career, Madison could barely bring himself to talk about the Senate without clenched teeth because he felt that equal representation in the Senate was a mistake. But I will leave that aside and let's take a look at the history of the Senate as it was up until the beginning of the movement for the 17th Amendment. It's common to say that the Senate during the early Republic functioned well as a kind of form of national wisdom, a place where the very great assembled and coolly debated the issues of the day. George Will, my former colleague at the Washington Post, wrote in 2009 that the framers established election of senators by state legislators, under which system the nation got the great triumvirate, Henry Clay, Daniel Webster, and John Calhoun, and thrived. To which my response was, have you ever met thriving? Because that's not it. In fact, to believe that the agony of the antebellum Constitution created a thriving nation requires a level of historical credulity I don't possess. The Senate was one of a number of structural flaws that contributed to the growth of two societies within the boundaries of the United States and the collapse of the constitutional order and the creation of a highly destructive civil war. So the general principle of legislative enactments is questionable in its origins and in its original function. I don't think it ever worked particularly well. But more to the point, from our point of view, is that after the Civil War, when we moved into what we now call the Gilded Age, appointment of senators, which had always worked fairly badly, began to work much, much worse. And that is because we had the rise, perhaps inescapable, with the onset of a 19th century industrial economy, we had the rise of massed wealth, both in individual and in corporate hands, that created what we now call special interests. This massed wealth, these forces, very quickly discovered that if you wanted to influence government policy, by far the cheapest investment you could make was the more or less wholly owned acquisition of a state legislature. It really was very inexpensive in the 19th century for major corporations and entrenched interests to descend on state capitals, spread their wealth around to the point that the candidate of their choice would be selected. Now, it didn't always work. And when it didn't work, that turned out to be worse than when it did. David Kivig, in a really wonderful book, which everyone in this room is clearly a constitutional nerd. You should all go out and read this book. Authentic and Explicit Acts Amending the U.S. Constitution, which is a history of constitutional amendment. He lays out the history of what happened in the Senate between the Civil War and 1913. What would often happen was that two or more of these established interests would arrive in the state capitol with the agenda of electing a senator friendly to their interests, and they would deadlock. And the conflict would become so intense that, in fact, the Senate would finish its session without actually being able to choose a senator at all. A number of, I think on 45 different occasions around the country, state legislatures were unable to elect a senator. The worst record was in Delaware, which went for 3 consecutive Congresses with, at first, only 1 senator and then subsequently none. I am an adopted Oregonian in addition to living here. And in Oregon, we remember what was called the hold-up legislature, in which a quarrel between silver mining interests and railroad interests led to the silver miners deciding the way to win the battle was to hire and rent an entire hotel in Salem, Oregon, which they staffed with excellent chefs and entertainers of a less reputable kind, and invited all the members of the legislature to spend the next 40 days at their expense in this hotel, as long as they would agree not to go over to the state capitol and constitute a quorum. And that, in fact, is what happened. The legislature never convened, and the state did without a senator for at least the next 2 years. That wasn't that unusual. And in fact, there were scenes of violence. There were scenes of conflict in the streets over whom the legislature would designate as a senator. George Haynes, the great historian of the Senate, said, and this is, I didn't write the exact quote down, but it's close. You know, it is not too much to say that with the election of senators, conflict reached the point of street violence and mob rule. So that system wasn't working very well, and the idea that this was producing an elite, sort of noble core of senators, I think historically doesn't bear scrutiny. And as a matter of fact, now I know that you guys all work and are very close to members of this body. I know that members of this body may not have the prestige in the nation that you might wish they would have, but I would think that if you compared the 100 people who hold seats in this building now with people who held seats in this building 130, 140 years ago, you would say, oh, thank God we have this noble bunch, right? And not that group. So outrage at the failings of this system began about 1890. And the story, as I said, of the adoption of the 17th Amendment is the story of a 25-year period of deep civic engagement by people all over the country aimed at using the Article 5 process to do something deeply patriotic and something the framers intended to be part of the constitutional system. And that is to change the system so that it would work well for the new conditions of a continental nation. I sometimes think that a lot of popular constitutional disputes just come about because Americans, because of who we are, don't develop historical memory as richly as some other countries. It is easy to forget that an event like the 17th Amendment does not occur randomly or suddenly. I wrote some time ago in a column about former Governor Perry of Texas, about the 17th Amendment, the American people did not, in fact, get drunk one night and get a tattoo. This was a very seriously considered process, okay? So I think that it's also worth asking, because 1913, as Todd so cogently said, 1913 is an important turning point in American history. And again, addressing popular constitutionalism, I can recall that perhaps 5 or 6 years ago, there was a great deal of feeling of outrage about certain provisions of the contemporary Constitution. And I used to see protesters down here wearing shirts that said, 1913, worst year ever. And what they meant by that, of course, was, as Todd notes, the adoption of the 16th and 17th Amendments. But I took that seriously enough to think, does that even make sense, even from any policy point of view? Because it seems to me that one could quite responsibly argue that 1913, the period between 1913 and 2013, constitute what historians might call the American century. That in the years after those structural changes in our government, we won 2 world wars and defeated communism worldwide. We fashioned a safety net for our seniors that has functioned extremely well. We defeated the Great Depression, which was such a scary event that people today don't like to think about it, right? And last but not really necessarily least, well, not last but least, we also got the vote for women. We finally enforced the promises of the Civil Rights Amendments to some extent, made the vote available to people regardless of color, and last but not least, put human beings on the moon. It's not such a bad record. And I would suggest to you that the 17th Amendment and the fact that people are engaged in electing their senators has played some role in transforming the United States from what it was, a fairly sort of loose confederation of states that was being knit together by economic interests, but whose government was having trouble adjusting to that, into what it is today, which is the richest, most prosperous, most productive economy in the world. So I would just as soon focus my efforts, because I'm not here to tell you, because I don't want to get run out of here, I'm not here to tell you that the Senate works perfectly and everything is great and every senator is noble, but I would like to see us focus our efforts on ways we can make the institutions we have work better than to lament what I consider to be the mythical lost paradise of legislative election of senators. And with that, I'll sit down and we'll see what people have to say.
Go straight to questions?
Well, I can do either one.
It's up to you guys.
It's up to you.
Yeah, let me just take 2 minutes. And first, I want to thank Professor Epps for his remarks. And I just want to highlight 2 things more in a way of discussion than dissension, which is the first is when we think about all these things is not to commit what economists refer to as the Nirvana Fallacy, right? And it's clear that prior to the 17th Amendment, moneyed interest and special interest often exerted a powerful influence over the election of senators. It's also clear after the 17th Amendment that moneyed interest and powerful special interest groups exert powerful influence over the election of senators in a different way. You might think it's more, you might think it's less, you may think it's better the role that money and special interest influence operates today than it did then. But we shouldn't sort of think about, commit the Nirvana fallacy, right? Because everybody knows, that this is part of it, right? Also related to that is the deadlocks points that Professor Epps points to, which are really important. There's an interesting historical example. There's a lot of discussion over that in the literature. One of the things that helped cause that was that there was a federal law that made it very difficult for states to actually elect senators essentially required them. It said that senators can only be elected by majority vote. One of the things that's interesting is that the 17th Amendment does not require election by majority vote, and often senators are elected by plurality vote. The last thing I want to say is just some way of discussion in framing this is, as I go around the country, and I've talked about this a lot and that sort of thing, almost every time I talk about this to a group, somebody comes up to me and they say, I've got the amendment that's going to save the Constitution and turn the country around, right? And it may be term limits, or it may be balanced budget amendment, or it may be, getting rid of partisan gerrymandering, maybe this or whatever. And here's the point, right? Here's the big point here is every time we tinker with the Constitution, we're going to get intended and unintended consequences. And every single time somebody says to me, this is going to be the thing that's going to save the Constitution, I basically say, well, what do you think might be the unintended consequences that would flow from that, right? And nobody ever thinks about the unintended consequences, right? The ripple effects and that sort of thing. And so I think that's one of the lessons we can learn from this experience is that there were a huge number of things that were expected. There were some things that were expected would happen. There are a huge number of things that weren't expected that were good, and a huge number of things that weren't expected that were maybe not so good, and sort of tabulating that and thinking about being cautious and being careful about sort of our own constitutional hobby horses, and understanding that repealing the 17th Amendment or any other constitutional provision is not likely to be a panacea that's going to save all our problems or create, or solve all our problems, but it may just create new problems.
So before we go to questions from the audience, I want to exercise my prerogative as a moderator and ask a couple of questions of our panelists. The first question that came to mind, because it is such a kind of a concept, and it was mentioned very briefly in the talks, it's kind of a novel concept to us today in sort of this modern era of mass media and social media and things like that, is this idea that state legislatures would have been in a position prior to the 17th Amendment, and perhaps still to a certain extent today, to give instructions to their senators. Hypothetically, assuming that we could enact a repeal of the 17th Amendment and revert back to some form of a system of indirect election of senators, and keeping in mind that even that, if I understand the history correctly, by the early 1900s, was not exactly as indirect as everybody wants to think, because most states had passed laws, or many states had passed laws, basically stripping the power from the state legislatures and saying you have to go with whoever the popular will would have elected had there been an election anyway. Setting that aside for a moment, what kind of world would we envision where the state legislatures would in fact exercise an instruction power? What might those instructions potentially look like, and what impact do either of you think that would have on the way the Senate sort of functions as a body?
And I'll just tackle that first, if that's okay. And I'll say very briefly, regrettably for me as a constitutional idealist, my very first job out of college as a boy reporter was covering the Virginia General Assembly. And that has dispelled any notions that I may ever have entertained that we can count on our state legislatures to function in a kind of noble capacity. I don't think the idea of instruction, of course, is an entirely different issue than popular election. And that was fought out, as Todd pointed out, in the antebellum era. The idea, as I understand it, you're much more of a specialist than I am, is that senators are federal officials. Once they take the oath, they are part of the federal government, and the states cannot instruct federal officials to do anything. And of course, we still have the 10th Amendment principle that the federal government cannot instruct state officials to do anything. And so I don't see repeal of the 17th Amendment changing that. That would take a much more robust change even than that. Now, Todd, how is that from your point of view?
Yeah, I mean, so what's interesting, under the Articles of Confederation, it was very clear that the members of the Congress were representatives of their states. States had both the power to instruct, formally, the power to instruct and recall, that basically if you didn't follow the instructions, could be recalled. There is no power of instruction in the Constitution. There's certainly no power of recall. What essentially happened was they continued the tradition of instruction, but it was in an informal fashion. And it was very, very sparingly used. States' legislatures rarely sent formal instructions to their senators. And senators, as I said, it saw it as an informal sort of constraint that they would either, on those rare occasions, they would follow the instruction or they would resign. The primary way in which senators were expected to kind of follow the state legislatures would be that the power of reelection. Right, that if they deviated too much and too often from the state legislature and in an informal fashion, they just wouldn't get reelected for another term, I think and that's probably right, I think, for the reasons that Garrett mentions. I think that the idea of an instruction with a recall under the federal Constitution probably doesn't make sense. I think the idea of instructions, right, saying it's the will of our state legislature, might make sense within the logic of the Senate, but it's all kind of moot once you take away the stick of and carrot of not being able to reelect the senator if they want to get reelected at the end of their term.
Well, I would add to that, not in disagreement, but just a kind of nuance. From my experience in Virginia and Oregon politics, which are the two places I've been active, It is certainly the case that the legislature cannot instruct a senator, and if they try, they get slapped around. But the legislatures are not unclear in transmitting to the senators what they think the state's interests are in a given litigation. And in my experience, the senators pay a good deal of attention to that because there is exactly what you said, the penalty of non-reelection if you ignore the will of the people, and certainly the legislature is seen as a reflection, not the embodiment, but the reflection of that will.
Questions? Back here.
Charles Schott, Center for Financial Stability. I have one question and two micro bite-sized observations. My question is that today, the closest thing we have to the old Senate is a building that sits at the bottom of Capitol Hill called the Hall of the States. Mm-hmm. And every state has a representative there that's appointed by the governor and perhaps confirmed by the legislature. But they're here basically to deal with the Congress for interaction with the states and programs and things like that. What nobody ever talks about is the power of the Interstate Compact. And it strikes me that it would not be a stretch to envision an Interstate Compact that would be created to create, in effect, a much stronger version of that organization of the states that might perhaps have a representative of the state legislature, perhaps one, not two, and have them work on resolutions, interstate consultations, new state compacts, and create a third role for the states that was more in line with what was originally envisioned. My two bite-sized observations are, you did not comment on how many states independently prior to the 17th Amendment went to the direct election of senators, and there were a number of them, if I'm not mistaken. And Professor Epps, I would quibble with your view about the post-1913 world as the source of this greatness. In American universities today, historians seem not to want to teach about the presidency from Andrew Johnson's impeachment up to Teddy Roosevelt's ascension. But in fact, it was that, I used to call those the lost episodes, because it was during that time that America, as evinced by McKinley and the American role in the Philippines and elsewhere, that America became a world power, and not post-1913.
Take the elections observation first.
Well, it is certainly true that states tried in a number of jury-rigged ways to make the system work as popular election. And they would have, for example, in Oregon, which was one of the first, they'd say that you had to indicate on the ballot whether you, as a legislator, would agree to vote for the candidate who got the most votes in a primary election that the state held. Two things about that. One is it didn't work as well as people say, and there were actually similar outbreaks of difficulty and deadlock after that, Illinois being the leading example. And the second thing was, you know, it was constitutionally a little dangerous in the sense that it was always open. There were legislative challenges about direct election of senators. It was always open to interpretation by the courts. And the 17th Amendment, I think, improved the situation by just saying, here's how it works. And, you know, elections for the Senate have been held since then. And by and large, they produce senators, which is what we want elections to do. So, you know, I don't think the kind of workaround was really, well, again, this is my theme. Like, you may or may not agree with the policy outcomes and the structural outcomes that the 17th Amendment produced. But by golly, if you care about constitutionalism, look at those people and what they did and how deeply they believed in Article 5 and in the Constitution as written, and at least just pause to take your hat off, because that is the value that both people like myself and the Federalist Society espouse: constitutionalism, allegiance to the way the framers set up a system and how they wanted the people to participate in them. And I think it's an inspiring story.
I would have to go back and look at the exact numbers. What I seem to recall was about 21 states, essentially what they did were straw polls, right? Where where they'd have where people would vote for the center of their preference. Like 21 states had that. Maybe 13 states had popular primaries before they did it. And it was interesting, and I think to Professor Epps' point, I think, which is very, very important, which is it was constitutionally questionable. And the way they would do it, the Oregon system was the sort of the prototype. And what they would do is it appear on the ballot and would be, Garrett Epps, Republican, Todd Sawicki, Democrat, right? Or maybe possibly the opposite way around. But it would say, and then it would be statement on the ballot. And it would say Garrett Epps, Republican, and another thing would say, I support the people's choice for the Senate, or it would say, I do not support the people's choice for the Senate, or something like that, right? They put it right on the ballot. Now, how do we know that's constitutionally suspect? Because that was the way a lot of states tried to do term limits, was that they put on the ballot, I pledge that I will only serve 3 terms in the House of Representatives, and the Supreme Court held that unconstitutional and said that that was an additional qualification, right? Now here, it might be different because it was state, right? Which is your state laws and state ballots, right? But the interaction with federal law, I think, was interesting. But beyond that, it wasn't just the direct election. There was even another strong direct election effect, which is why did Lincoln and Douglas barnstorm around Illinois? Right? And they were basically trying to get people to vote for the state legislator that would vote for them, right? And this is David Schleicher's critique of my position. And David says basically that by that time, the national parties had basically taken over everything. And his view, I think, is I don't fully agree with it, but I think he has a point, which is he says direct election senators may have actually strengthened federalism in some sense by allowing state legislators just to focus on state issues rather than, as it had become at least to some extent, voting for your state legislator as a referendum on who you wanted as your U.S. senator. I think that overstates a lot. I think the Senate continued to serve its function, although imperfectly, but that was another way in which sort of popular pressures and democracy were kind of overrunning the banks. I'll just add one last point to your other point, which you asked about, the state compact thing. I don't have a strong view on that. I think it's an interesting view. I think those are the kind of things we should be thinking about, right? We shouldn't just assume that changing the way the Senate was elected didn't fundamentally transform our Constitution, because I think it is. It's that. One other thing we don't really think about is right now, there's really no way for states to directly propose a constitutional amendment. Nobody thinks a constitutional convention is really viable. But back before the 17th Amendment, at least in theory, the states via the Senate could introduce a constitutional amendment to be voted on the Senate and then sent to the House and then sent to the states for ratification. Right now, there's no real way for states to directly place something into play as a possible constitutional amendment under Article 5, which I think may be another way of thinking about this, which might be to do something to allow the states to basically propose constitutional amendments that then would have to be voted on by state nominating. I mean, you can imagine different ways in which that might play out, but what we've seen is most constitutional amendments, at least since the Civil War, have enlarged the power of the federal government, except for, I guess, the 21st Amendment. And states haven't had any real way of perhaps proposing things that might restrict the federal government or do other sorts of things.
Well, I want to say 2 quick things about this. And one is that if we did come up with a provision by which states could propose constitutional amendments, that would actually not be returning to the status quo before the 17th Amendment, because they couldn't do it then. And the evidence is states kept sending messages to their senators saying, we want you to propose direct election of senators. And sure, and the senators were like, well, here's a letter from home. So that's important to remember. The other thing I wanted to say in response to the gentleman's substantive suggestion is that, I get all shivery when someone says interstate compact, because, that's even more obscure, more nerdy than the 17th Amendment. I'm really excited about it. We're almost heading into Third Amendment territory, the Third Amendment being the ultimate constitutional nerd thing. So I think thinking in terms of compacts is really a wonderful thing to be doing, quite seriously, and I want to encourage that.
Right up here in the front.
My name is Jim Calderwood, and I believe, and I'm going to let you historians correct me, that in most of the historic time of America, we did not have a full-time Senate and a full-time House of Representatives. And that evolved gradually to what we have today, where effectively both houses of Congress meet 12 months a year. They never go home. And so what I'm getting at is how much that had to do, if at all, with the passage of the 17th Amendment was the fact that they basically evolved into a full-time job. If you state legislatures today, legislature in Maryland can only meet for 90 days a year. I believe in Texas, they meet only every other year. I think in Virginia, they meet, they have different sessions. One year they can only do the budget or something like that. But there are limits on state legislatures to how long they can meet, but no limit on the U.S. House and Senate. Has there ever been such limitations? Did they just historically meet for a couple of months and then everybody went home? How did that evolve?
I don't know the answer to that, but I will share this one anecdote with you that I just think evokes a far-off America in a way that's very, very dear. And that is that when the 39th Congress was debating the 14th Amendment and trying to deal with the aftermath of the Civil War, two of the leaders were William Pitt Fessenden of Maine, who was a leader of the sort of Republican group that was trying to remodel the Constitution in order to preserve the gains of the Civil War, and Reverdy Johnson of Maryland, who had represented the slave-owning family in the Dred Scott, but was a Unionist. And the two of them were also among the leading Supreme Court advocates of their day. And so it was not uncommon for them to go down to the Senate basement in the morning and argue a case in front of the U.S. Supreme Court, and then come up to the Senate and take part in debate. And sometimes Fessenden would get so tired, he would have to lie down in one of these windows and take a rest on the floor. So it really was a different world. I'm not sure.
When Lincoln was in Congress,
Yeah.
I think he argued two cases for the Supreme Court while he was here.
When he had one case. And he lost, by the way. But you know, I'm not sure. I don't know how we could go back to a part-time legislature, and therefore I'm not sure I know whether it's desirable or not. Todd?
I suspect air conditioning had more impact than the 17th Amendment on Washington sitting year-round. No, I mean, obviously, there's been huge changes in transportation and other sorts of things, and the job's just gotten bigger. So, you know, there's a lot of dynamics involved in that.
My name is Ted Gebhardt. I'm a retired antitrust lawyer. One brief comment and one very brief question. Comment is, I would just point out that 1913 is also the year of the founding of the Federal Reserve System, which I would suggest over time intensified the adverse effects of both the 16th and the 17th Amendment, ultimately leading to a very rapid growth of the federal government, unconstrained by guns and butter spending that we see today. The question is, and this is more just curious than anything else, prior to the 17th Amendment, and adjusting for the staggered terms of the two senators from each state, I'm wondering if a state legislature, most of which I assume were bicameral as today, except for Nebraska or something like that, if both houses of the state legislature were of the same party, did you tend to find both senators of the same party? What happened in instances, generally, if the bicameral legislature, state legislature, were of two different parties? And were there instances where, even where the legislature, both houses were of the same party, you occasionally had legislatures electing a senator or sending a senator to Washington from the opposite party?
Yeah, two thoughts. First, on your first point, which I want to pick up on in the Federal Reserve. I mean, obviously, one of the big issues here is just the rise of progressivism, right? And the progressive vision of the Constitution was just different from the framers' Constitution, right? The framers, I think, were concerned about preserving individual liberty and reducing the power of factions, right? And creating a lot of obstacles to government action that were consistent with that. The progressive vision was very different. And the progressive vision was it wasn't a clear vision, right? So, for example, the urban political machines were big supporters of the 17th Amendment. Why? Because in the states at that point, state senates, for example, state legislatures are often malapportioned in favor of rural areas. Urban machines basically saw the 17th Amendment direction of senators as a way of circumventing state legislators, which they saw as, or which were malapportioned, and basically electing senators directly. They also knew that they could get their people to the polls, right? And so progressivism is not a clear sort of thing, right? But it was a bootleggers and Baptists sort of story where urban machines were in favor of it for one reason. Certain interest groups are in favor of it for certain reasons, like labor unions and that sort of thing. And sort of people who just thought it was good government, right? Muckraking journalists and that sort of thing. So it's a very interesting hodgepodge. On your second point on state parties, one of the things that's interesting, I've looked at a lot of this history, and there is an interesting dynamic here, which is, and if you look at the actual debates, a lot of it has to do with things you wouldn't expect. So the debates around the 17th Amendment, Western states basically said, we need to elect senators directly because we're losing out in Washington, right? And I did some empirical research, and what I found was, on average, Western state senators had shorter average seniority in Washington than people from other parts of the country, notably the South. After the 17th Amendment was enacted, that evened out, that basically the average seniority differed. And I think one of the reasons, to your point, Ted, was that West at that point was essentially a three-party system, right? It was Republicans, progressive Republicans of the Bob La Follette type, and Democrats. And so they had a lot of churning of majority coalitions in state legislatures, and I think what that was causing them to do was to churn their senators a little bit more. And so basically by removing it from the hands of the state legislatures, they were basically making sure their senators would be on equal footing to get the pork and the stuff that they wanted for the Western states with the rest of the country. And so I think there's some evidence to suggest that that was part of the story as well. I haven't seen any evidence that a state that was controlled by one party sent a senator from a different party as their representative to Washington. It could be. I haven't looked systematically at that, but I'm not aware of it.
I'm going to say something that's only tangentially related, but I think does flow from it. And I'm going to start by saying, and I honestly hope nobody will go outside this room and repeat what I'm about to say, because I'm going to say about the U.S. Senate something that is said in the old joke from the Soviet Union, where one worker says to another, what do you think of Stalin? And the other one says, for the love of God, don't tell anyone, but I like him. One of the things that I'm fond of about the current U.S. Senate is that with the rise of the gerrymandered state district system, that the Senate is now the hotbed of democracy, because if you are a senator, you have to run for re-election and try to get to win a plurality of the votes of all the people in the state. You can't pick who can vote for you and who can't, and I would hate to see us lose that.
Good afternoon, gentlemen. I'm J.P. Mantone with defense fellow for Senator Collins. I'm not a lawyer, but a constitutional nerd and a Third Amendment activist at that. So, yeah.
All right.
What are your thoughts, if there's any truth to the claim that there was a flaw to the Senate before the 17th Amendment? It was the equal proportion amongst the states as opposed to how they were simply elected, and if that reflects sort of the worst trends of the Articles of Confederation.
I'll say quickly, and then you can say whatever you want. Yes. It's a terrible system. Madison absolutely hated it, and it does not serve us well. But I don't know what I can do about it. And so, like all other Americans, I just suffer.
Yeah, I mean, I think, that's a whole nother debate, right? Some people have argued that it's really the equal representation that gives the Senate the clout of the states, and even more so now. It's pretty obvious, the counter-argument. I was laughing when Professor Epson noted that when James Madison was a member of the House of Representatives, he thought that the Senate was all messed up. I guess as much as things change, some things stay the same, right?
Other questions? If there's one more?
I'm Rick Dykema with Congressman Dana Rohrabacher. When I've heard about this 17th Amendment proposal before, I usually hear about it in terms of people saying, oh, it's the state legislators that ought to be represented, and that's the only thing they're talking about. Professor Sawicki did bring in the other parts of it, which were they're trying to insulate these senators from political pressure, clearly also from the state legislature, because otherwise you'd have no purpose in having two senators rather than one, no purpose in having a 6-year term if you wanted them to be directly and responsible to what the state legislature wanted them to do. And so I guess the question, which I guess you partly answered it before, but in your view, you would not say that the highest value here is to make sure that senators are responsive to their state legislators, and you think the other parts, the 6-year term and the 2 senators with staggered terms, are important to keep as well?
Yeah, I would say 2 things, which is I keep going back to the importance of bicameralism, because while today we focus on the federalism impulse, to the framers, and I think if you read, I'm a constitutional economics nerd, going back to Buchanan and Tulloch and the calculus of consent, right? Bicameralism, separation of powers and the like, right? Which is, they saw bicameralism as equally important as federalism in this, and the idea of having 2 bodies elected by different constituencies that would check and balance each other and raise the level of consensus necessary for legislation to be enacted as a check on factionalism. So I would just want to emphasize that again, that I think that having 2 bodies implies bicameralism, and if the bodies are very similar, the argument for bicameralism, I think, is much weaker. I do think that another part of it is the idea that that indirect election and buffering them, senators from direct control by the people or state legislatures, was seen as part of their design, again, right, for confirmation, treaty ratification, confirmation of nominees, treaty ratification, all the other sorts of things. A lot of things that they do are related to impeachment, right? I think a lot of these really only make sense in a world where there's going to be some buffer between them and any direct political impulse. The states' primary role is basically to have them protect the states as states in a federalism sense. Impeachment, confirmation, those sorts of things, I don't think really go to that functional part of it. And so to the extent that it basically protects states from things like federal overreach they think is inappropriate, or unfunded mandates, and that sort of thing. The final thing I would say is the big picture here, right, is Madison's view that it was the auxiliary precautions that would be the primary protection of liberty and the limitations of factions rather than direct control by the people. And the idea, again, which you may agree with or disagree with, essentially the idea is that the system, the whole, is bigger than the sum of its parts, right? Which is that the interaction of the 4 elements, the presidency, the House, the Senate, and the judiciary, that interaction of these 4 different bodies responding to different impulses, responding with different degrees of independence, responding to different constituencies, that somehow that interaction would generate results that would be more conducive to liberty, prosperity, and the like. That was their hypothesis, right? That was their thesis. I just came across a wonderful quote, literally just over the weekend. I was rereading some of this material, and there's this wonderful quote where Woodrow Wilson says, you have to, and he's writing, in 1913, so Darwinism in the air. He said, the way you have to understand this is the framers had a Newtonian view of the Constitution. They wrote in their era, which is the Newtonian era, which is the system's all about balances, right, and countervailing forces and that sort of thing. And Wilson says we're now in the Darwinian era. Constitution's about evolution. It's about change. It's about progress, right? Those intellectual conceptual ideas underlay a lot of this, right, in terms of what the framers are trying to accomplish, what the progressives are trying to accomplish, and whether these four pieces balancing each other, right, are good, like the framers thought, or whether they are obstructing and slowing down and blocking good social progress, which is how Wilson saw it, right, getting in the way of evolution, and the Constitution has to change to fit with the forces of progress of the country. The framers saw the Constitution as basically creating the conditions that are conducive, as somebody mentioned, right, for prosperity and freedom. Wilson saw the Constitution as basically being part of that evolutionary process and being swept along with those processes, I think.
The one thing I'll say is that it seems to me, looking around, that bicameralism is alive and well, regardless of the 17th Amendment. If we look at the number of measures that come out of one house and don't get through the other, and I won't name no names, but that is exactly what bicameralism is about, and you may approve of it or disapprove of it, but I think it has not disappeared.
With that, we will say thank you to our esteemed panelists and audience, and everybody wish us luck.
A lot of fun.